Hey everyone, welcome back to Myra Stories. Today's story isn't just about power, it's about what happens when someone tries to use it on the wrong person. Buckle up because when Supreme Court Justice Amy Coney Barrett tried to corner Elon Musk in court, she never imagined he'd corner her right back. And it all started with a subpoena, a smirk, and a speech that left the entire courtroom in stunned silence. It began quietly, as these things often do. A sealed letter, marked confidential, landed on Elon Musk's desk at X Corp headquarters. It wasn't just any legal document. It was a subpoena signed by none other than Supreme Court Justice Amy Coney Barrett. Its contents? A directive to appear before a special judicial hearing regarding alleged violations of federal regulatory protocols surrounding free speech and platform moderation policies. At first glance, it looked like yet another bureaucratic nuisance. Musk had seen plenty of those, but the name at the bottom, Barrett, changed everything. This wasn't just a regulatory slap on the wrist. This was a high-stakes game of constitutional poker, and Justice Barrett had just thrown down the first card. Most CEOs would panic, not Elon. Instead, he leaned back in his chair, stared at the letter, and smirked. By the time the hearing date arrived, Washington buzzed with speculation. Why had Barrett taken such a direct interest in Musk? Was this political, personal, or was it about sending a message that no one, not even a tech billionaire, was beyond the reach of the law? The courtroom was standing room only. Reporters jostled for space. Senators whispered from the back benches. Legal scholars clutched notepads, eager to see the courtroom clash that was being dubbed the government versus genius. And then came Musk. No entourage, no legal team flanking him, just Elon, crisp navy suit, no tie, walking calmly toward the bench with an armful of documents. Justice Barrett wasted no time. "Mr. Musk," she began, "you are here today not because of who you are, but because of what you've done. Your platform has repeatedly failed to comply with federal communications oversight standards, especially concerning the regulation of politically sensitive content." She paused for effect, letting the weight of her words settle. "The question before us is simple. Do you believe your wealth places you above the law?" The air went still. Musk's response was immediate, calm, and razor sharp. "No, Your Honor," he said, "but I do believe the Constitution does." The courtroom gasped. Barrett blinked. And just like that, the dynamic shifted. Musk stepped forward, calmly placing a thick binder on the evidence table. "This," he said, "is 214 pages of precedent, Supreme Court rulings, federal interpretations, and constitutional arguments, all of which affirm the limits of federal oversight over private digital platforms protected by the First Amendment." Barrett raised an eyebrow. "Are you representing yourself, Mr. Musk?" "I am today," he replied, "because this isn't about money. It's about power, and whether that power belongs to the people or to a court trying to silence them." For a moment, Barrett said nothing. Then, "Proceed," and Musk did. He outlined cases from Reno versus ACLU, Packingham v. North Carolina, and even Citizens United, weaving them seamlessly into a defense that sounded more like a TED Talk than a legal deposition. He quoted Justice Scalia, referenced obscure legal doctrines, and even challenged the foundational assumptions behind the FCC's regulatory reach in the digital age. It was mesmerizing. Even Barrett, known for her cool detachment, looked visibly intrigued. She interrupted twice, not to correct, but to question, to learn. And as Musk continued, a strange thing began to happen. The courtroom that had arrived expecting a smug billionaire getting his comeuppance began to shift. The whispers turned to nods, the scowls to curiosity. Barrett herself leaned forward, because in that moment, it wasn't just Elon Musk versus Amy Coney Barrett. It was Elon Musk versus the system, and the system was listening. When Caroline Levitt concluded her legal defense, the courtroom wasn't just silent, it was stunned. Even seasoned court reporters, used to years of oral arguments and high-stakes showdowns, were frozen in their seats. What they had just witnessed wasn't merely a political figure speaking. It was a constitutional tour de force from a woman no one had expected to be a legal gladiator. Justice Amy Coney Barrett leaned slightly forward on the bench, her expression unreadable. She flipped through the notes in front of her, a faint crease forming between her brows. For the first time in her career, she wasn't questioning a lawyer. She was questioning whether her very challenge had just been neutralized, publicly and perhaps permanently. And just then, Chief Justice John Roberts broke the silence. Ms. Leavitt, are you aware that few individuals without a legal degree could recite New York Times for Sullivan with such accuracy? Leavitt nodded calmly. Yes, Chief Justice, but this isn't about degrees. It's about the Constitution, and no American should be silenced for upholding it, especially not in public discourse. A murmur rippled through the courtroom. What happened next changed the tone entirely. Behind the scenes, justices retreated to private chambers. There was no immediate ruling, no dramatic gavel bang, but rumors began swirling that some justices were rethinking their position entirely. And not just on the contempt case, but on the precedent it could set. Later that afternoon, an internal memo from Justice Sonia Sotomayor began circulating. In it, she argued that prosecuting Leavitt for contempt would violate core First Amendment protections and risk turning the court into an instrument of suppression rather than balance. Outside the courtroom, the media had already erupted. Headlines screamed, Press Secretary Schools Supreme Court, Leavitt versus Barrett, a constitutional showdown. When the bench met its match, social media was ablaze. Hashtags like Shot Leavitt Law, Shot First Amendment Hero, and Constitutional Queen were trending globally. But behind the fanfare, tensions were growing. According to insiders, Justice Barrett was deeply troubled, not just by Leavitt's defense, but by her own motivation. Had she overstepped? Had this become personal rather than principled? The White House, meanwhile, remained officially silent. No press releases, no public backing of Leavitt, but a tweet from President Musk, just 2 words, added fuel to the fire. Constitution wins. Speculation soared. Was the president subtly defending his press secretary, or was he challenging the Supreme Court's authority altogether? In Washington, those words carried weight. By day's end, court clerks confirmed no ruling had been issued. The bench was split, not just ideologically, but emotionally. And Caroline? She returned to her office quietly, her binder still under her arm. Reporters shouted questions, but she said nothing, just a faint smile. Little did anyone know, in a sealed envelope on her desk sat a draft of a congressional resolution, one she had written months earlier, calling for judicial restraint in public speech cases. That draft was about to become the center of America's next great legal battle. The next morning, Caroline Leavitt sat at her desk, alone, early, and strangely calm. The binder that had stunned the Supreme Court now rested in front of her like a sleeping dragon. But it wasn't the binder itself that had Washington whispering. It was what was inside it. For months, Leavitt had been compiling a comprehensive proposal, a resolution urging Congress to reaffirm the First Amendment's protection of political speech, especially when expressed by public officials outside the courtroom. She'd written it in quiet moments between press briefings, policy calls, and late-night research sessions. No one had asked her to. No one even knew it existed. Until now. Word had leaked, not officially, but through a friend of a friend circuit that D.C. thrived on. By noon, staffers from both the House and Senate were requesting to see it. But one call changed everything. It wasn't from a senator or a journalist. It was from Justice Amy Coney Barrett's clerk. Justice Barrett would like to review the contents of the binder. Privately. Caroline froze. Was this a trap? A chance for Barrett to discredit her work? Or was something shifting? Meanwhile, within the walls of the Supreme Court, the atmosphere was tense. Justices who had initially sided with Barrett now began to reconsider. Justice Kagan reportedly told a colleague, Leavitt might be brash, but she's not wrong. If we don't draw a line now, what happens when political speech becomes prosecutable by whim? Back at the White House, President Musk convened an emergency communications briefing. We don't escalate, he said calmly. The courts must come to their own conclusion. But make no mistake, this moment defines the balance of power for the next generation. Behind closed doors, Barrett sat with the binder. Page by page, her expression shifted, not to outrage, but to reflection. Leavitt hadn't just cited cases. She had crafted a constitutional map, guiding readers through a labyrinth of doctrine, precedent, and principle. On the final page, a handwritten note: "This isn't about me. It's about every American who dares to speak truth when silence is easier." Barrett closed the binder and exhaled. Alone in her chambers, she wasn't a justice wrestling with public pressure. She was a woman confronting her own legacy. That evening, a press advisory was quietly added to the Supreme Court's calendar. Special statement: Justice Amy Coney Barrett, 10 a.m., Friday. No one knew what she would say, but everyone sensed it would matter. Outside the court, protesters began to gather, not in anger, but in hope. College students held signs that read, "Speech is freedom," while legal scholars called the case the defining First Amendment moment of the decade. And Caroline, she remained silent. Her binder now lived in two places, her desk drawer in Barrett's chambers. But by morning, it would live in history. Later that evening, far from the cameras and courtroom drama, Justice Amy Coney Barrett sat alone in her private chambers, the soft glow of a desk lamp casting shadows over towering bookshelves and leather-bound opinions. She stared at a document on her desk. It was DeLance's testimony, now marked Official Exhibit A. Her fingers hovered over it, hesitant. How did it get this far? She had walked into this case thinking it was a simple confrontation, a regulatory compliance issue against a tech billionaire known for pushing boundaries. She didn't expect this. There was a knock at her door. It was Justice Kagan. "Amy," she said, her tone quiet but heavy, "you saw the documents. What do you make of it?" Barrett hesitated. "It's damning. If what DeLance says holds up under scrutiny, we're not just looking at overreach. We're looking at a coordinated censorship infrastructure. And Musk, he might have been the only one who had the guts to say no." Kagan nodded. "The executive branch used fear as a tool, just like he claimed." Barrett sat back, arms folded. "I didn't think he'd come prepared like that. I thought he was just a tech libertarian running his mouth." "Well," Kagan said with a slight smile, "he's a libertarian all right, but definitely not just running his mouth." They shared a rare, quiet laugh. Barrett tapped her pen on the table. "This goes beyond Elon. If we rule against him now, we'll set a precedent that speech can be conditioned by pressure, not law. That's not regulation. That's manipulation." She pulled out a copy of the First Amendment and read it aloud, almost to herself. "Congress shall make no law abridging the freedom of speech." It was simple, and yet everything they'd heard in court contradicted it. Just then, her phone buzzed. It was an encrypted line. "Barrett," she answered. A pause. Then a voice, deep, controlled, and familiar. "Amy, you're being watched very closely. Don't let this case spiral into chaos. You understand?" She didn't reply right away. The voice continued. "You have a legacy to protect. So does the court. Dismiss the testimony. Stick to the original scope." Click. The call ended. Barrett sat still, the silence pressing in. She looked down at the transcript again, at Musk's calm reasoning, at DeLance's damning evidence, and at the quiet revolution brewing right under their feet. Legacy? She wasn't worried about her legacy. She was worried about the truth. And in that moment, a shift happened. Barrett, once determined to put Musk in his place, now found herself preparing for something else entirely. Not a reprimand, but a reckoning. "Good morning, Your Honors," Elon Musk began, standing tall at the center of the courtroom. But this time, he wasn't just another defendant. He was leading a constitutional confrontation. The courtroom was buzzing. Journalists, constitutional law scholars, tech leaders. Everyone had flown in for this hearing. And for the first time in modern history, a billionaire CEO was about to challenge the U.S. government on First Amendment grounds, directly in front of the Supreme Court. Justice Barrett leaned forward. "Mr. Musk, proceed." Musk didn't miss a beat. "I'd like to introduce into the record Exhibit B, the Garrison Doctrine." He clicked a remote. A projection appeared, a landmark 1964 Supreme Court case, Garrison versus Louisiana. "In this case," Musk said, turning to the bench, "the court ruled that even false statements about public officials are protected under the First Amendment, unless made with actual malice." Barrett nodded. She knew the case well. Musk continued. Yet here we are today, where federal agencies, under the guise of protecting public interest, actively coerced platforms to suppress entirely true statements. Not defamatory, not malicious, but simply inconvenient. The justices murmured among themselves. Musk turned back to his notes. In 2021, my platform received no fewer than 87 flag content removal requests from federal offices. Each one was phrased as a recommendation, but implied consequences if ignored. That's not a suggestion, that's soft censorship. And it's unconstitutional. He let the silence sink in. Justice Sotomayor asked, Mr. Musk, are you implying that government pressure equals a violation of state action doctrine? I'm not implying it, Your Honor, Musk replied. I'm asserting it. When the government uses its influence to suppress speech it doesn't like, through private actors it becomes the de facto censor. That's not just unethical, that's illegal. Barrett raised an eyebrow, clearly impressed. Then Musk delivered the blow. I submit a motion under Rule 60B to vacate the entire basis of the government's regulatory complaint, not due to procedural error, but because the underlying actions were conducted in violation of the First Amendment. I'm not just defending myself here, I'm defending the very framework of American liberty. Boom! The room exploded into whispers. Barrett whispered to Kagan, He's not wrong. Gorsuch nodded slightly. If we dismiss this on regulatory grounds, we're enabling the government to keep doing it, off the record. The momentum was shifting. What started as a compliance hearing had evolved into a landmark free speech case, and Musk of all people had turned it around. Barrett tapped her gavel. We will recess and deliberate on the motion. This court will reconvene in 72 hours. As the judges filed out, Musk stood still, his expression unreadable. And outside, protesters gathered, media scrambled, and hashtags like Murray Musk's the Machine and Musk's First Amendment Warrior began trending globally. As the Supreme Court prepares to rule on a historic First Amendment proposal, someone is back. Someone who had vanished until now. Her name, Lena Whitmore. She was a former legal aide at the FCC, now turned whistleblower. Months ago, she mysteriously vanished after leaking internal memos that exposed high-level coordination between government agencies and social platforms. But this morning, without warning, she walked straight into the Supreme Court press gallery, holding a flash drive that could shake the foundation of American regulatory power. As the court reconvened, Justice Barrett glanced toward the press row, her eyes locking briefly with Lena's. Musk looked up. He recognized her immediately. Your Honors, his attorney announced, we request an emergency evidentiary submission. Barrett raised an eyebrow. On what grounds? New audio recordings from within federal compliance briefings, featuring explicit language about silencing Elon Musk and suppressing constitutional speech through third-party enforcement. Gasps filled the room. Barrett leaned forward. Proceed. Lena stepped into the witness box, composed but visibly emotional. She took the oath, then connected her flash drive to the projection system. The courtroom lights dimmed. Then came the voice recordings. We don't need to order Twitter to comply, said one senior FCC official. We just make it clear that if they don't, they'll face compliance reviews and regulatory pain. Another voice added, Musk thinks he's untouchable. Let's remind him that we write the rules. The room was dead silent. The audio ended. Then Lena spoke. These weren't isolated comments. This was policy, internal strategy meetings, targeting speech, not for safety, but for control. And when I pushed back, I was sidelined, silenced, and eventually threatened. Justice Barrett's face hardened. She glanced at her fellow justices, visibly disturbed. This court, Lena added, must decide whether we still honor the First Amendment or whether we've allowed shadow censorship to become standard operating procedure. Barrett sat back. For the first time in the entire case, she looked shaken. Elon Musk, she said softly, this court owes you more than a ruling. It owes you the truth. Musk didn't reply. He didn't need to. The recordings had said everything. Justice Gorsuch whispered something to Alito. Ketanji Brown Jackson looked visibly upset. The bench wasn't just listening anymore. They were reconsidering everything. Barrett spoke again, this time to Lena. Thank you for your courage. Then addressing the court. This hearing is suspended for judicial review of the new evidence. A formal decision will be issued within 10 days. The gavel fell. But outside that courtroom, a media storm was exploding. Lena Whitmore had just become a national hero. Musk, once cast as a villain, was now seen as a champion of free speech. In the Supreme Court, it now stood at a constitutional crossroads. Hey everyone, welcome back to Myra Stories. We've seen power struggles before, but this one, it's personal. Because today, we're not just watching a courtroom drama unfold. We're watching a Supreme Court justice wrestle with her conscience. Live. Justice Amy Coney Barrett was silent for nearly 2 days. No statements, no interviews, not even her staff could reach her for comment. Why? Because after Lena Whitmore's explosive testimony and the audio evidence that sent shockwaves through Washington, everything changed. And the person most shaken by it was Barrett herself. You see, up until now, she believed Musk was playing the victim, that his defiance was ego, that his attacks on regulatory overreach were exaggerated. But those recordings, they weren't opinion. They were proof. And the question burning in Barrett's mind was this: have I become a protector of the system instead of a defender of the Constitution? Inside her chambers, she reviewed Musk's full submission again, then Lena's transcript, then one by one the internal FCC memos obtained by X-Corp's legal team. Lines that read, influence the platform even if we don't have jurisdiction. Create the pressure, let them crack under PR scrutiny. Musk must be made to comply. It wasn't just strategy, it was coercion. And Barrett knew, if she ruled against Musk now, she wouldn't just be upholding the law, she'd be enabling tyranny. She called a private meeting with Justices Sotomayor, Gorsuch, and Kavanaugh. Not protocol, but necessary. We need to talk, she said. In that closed-door session, Barrett laid it all out. The constitutional crisis, the overreach, the betrayal of public trust. Sotomayor, typically cautious, simply nodded. I've been worried about this for a long time, she said. Gorsuch added, this case may be our Marbury versus Madison moment. It was that serious. So when the court reconvened, the country held its breath. Barrett entered the chamber slowly, her face calm but intense. She looked directly at Musk. Mr. Musk, she began, what began as a regulatory hearing has become a reckoning, not just for this court, but for every institution that claims to serve the people. You could hear a pin drop. This court has reviewed the new evidence and unanimously agreed. The regulatory actions taken against you constitute a violation of First Amendment protections. Further, we recognize the danger of shadow enforcement and indirect censorship conducted under the guise of compliance. Barrett took a deep breath. And I'll say this personally, not just as a justice, but as an American. You were right. Musk remained silent, eyes fixed on hers. The people owe you thanks, Mr. Musk, and the Constitution owes you restoration. A thunder of murmurs filled the room. Outside, the media exploded. Musk wins landmark Supreme Court ruling. Justice Barrett breaks with bureaucracy. First Amendment strengthened in historic decision. But for Barrett, this wasn't just about the law. It was about redemption. She didn't just defend the Constitution, she rediscovered it. When Elon Musk walked out of the Supreme Court that day, he didn't smile. He didn't wave to cameras. He didn't even speak to the press. He just looked up at the towering columns of the courthouse and exhaled. Because what had just happened wasn't just a legal victory, it was the vindication of principle. And for Musk, that meant more than headlines. But while he might have walked away quietly, the world, it exploded. Within 24 hours, the FCC launched an internal ethics probe. Multiple federal agencies began reviewing prior regulatory actions involving tech platforms. Civil liberty groups hailed the case as a landmark defense of First Amendment rights in the digital age. And Amy Coney Barrett, her journey was just beginning. She became a surprising icon, not for any political camp, but for constitutional courage. In interviews, she spoke candidly. I confronted bias, my own, and I'm grateful I did. Her honesty sparked a national conversation. How many justices, lawmakers, or leaders are brave enough to admit when they're wrong? Meanwhile, Musk announced a new initiative. Not a tech project, not another rocket, not even a company, but something far more daring. The Liberty Protocol, a legal defense fund, an open-source transparency framework to help whistleblowers, content platforms, and ordinary citizens fight against unconstitutional censorship and regulatory bullying. It's not about me, Musk said in a rare public address. It's about making sure no one else has to go through what I did, alone. The fund raised $100 million in 6 weeks. Global leaders took notice. The European Union reviewed its own digital speech codes. Canada postponed enforcement of its controversial Online Regulation Act. Even the UN requested Musk speak at a global summit on digital rights. The ruling didn't just shift legal precedent, it redefined the balance of power between tech and government. And for once, it wasn't David versus Goliath, it was David, with a law degree, teaching Goliath the Constitution. As the years passed, the case became required reading in law schools. The decision was studied in debates, cited in rulings, and discussed in every serious conversation about tech freedom. But the most powerful legacy? A simple quote carved into the granite steps outside X Corp headquarters, visible to every visitor. Truth doesn't need permission. It only needs courage. And right below it, 2 names: Elon Musk, Amy Coney Barrett, 2 rivals, 2 minds, and in the end, 2 patriots. If this story inspired you, shook you, or even made you rethink the power of the individual, share it. Because sometimes the courtroom isn't just where justice is decided. It's where history is made. Be brave, be curious. This was Myra Stories. This